The CCFR has decided to go all the way to the Supreme Court to challenge the negative ruling they received from the Federal Court of Appeal. But is there anything they can say to make a difference? Let's have a look. Quick disclaimer before we get going here. I actually wrote this script for the video over the course of about the last week here, and just as I was getting ready to record, the CCFR announced that it actually would, in fact, be applying for leave to appeal to the Supreme Court. Now, this is going to be a bit lazy on my part, but I'm not actually going to be amending the script. So if at any point you hear me refer to the idea that they may be going to the Supreme Court, or if they can go to the Supreme Court, things of that nature, they've already actually decided to do so. However, I do think there's still a lot of good ideas in here, and maybe actually some of them are a little bit more precarious than anything. But ultimately, this video was always supposed to be just a brainstorming video, so hopefully they can put some of it to good use if the Supreme Court decides to hear their case. Welcome back to the channel. So today we're going to be continuing our CCFR versus Canada series. In our previous episode in the series, we took a look at the recent negative ruling handed down by Chief Justice Montigny at the Federal Court of Appeal. And as many of you already know, the CCFR and friends lost their appeal in a unanimous decision on all fronts. It was a pretty crushing defeat, especially with how relatively positive the hearing itself actually played out. I felt we comfortably met our burdens of proof, whereas the government's lawyers really sort of fell flat on their face for the most part. Yet, despite all of that, the Federal Court of Appeal was still all too happy to rule in their favor for some reason just unbeknownst to me. Because after having the last month to go over this ruling a few times, something really stood out to me. This ruling is weird. Weirdly weird. Because unlike in Justice Kane's ruling, where she was wrong because she simply either ignored evidence or just didn't care to understand what we were saying, Chief Justice Montigny, for the most part, actually did a pretty good job of analyzing the evidence and understanding what we were saying. Yet for some reason, he didn't really consider the totality of the arguments. Which does sound like an Injustice Kane type move, but when you read the more specific rationale he used to back up these ideas, that's where things get strange. Most of the time where the Chief Justice pointed us to some other precedents or some quote from the parliamentary record or whatever else in order to support his points, he actually ends up directly proving why his own ruling is wrong. And this happened particularly in regards to two of our strongest points. And these were the issues regarding the Intra Vires nature of the OIC, as well as the vagueness of the use of the word variant, and therefore also the unlawful subdelegation of authority. So in a way, it was a bad thing because we lost the case yet again, but it's also peculiar because he also more or less handed all the ammunition we needed in order to go to the Supreme Court and, I think, overturn his ruling. It almost feels like the court wanted to help, but they didn't want to put themselves out there and step in front of the government on their own accord. It felt like they would somehow prefer it if the Supreme Court was the ones to do it for them. But it's really not as simple as all that. Because after all, the Supreme Court hears less than 10% of the applications they receive. Even if we do have credible grievances with our latest ruling, the odds are still not anywhere near promising enough for us to have any kind of a guarantee that our application would even be heard. So for today, this video is going to be something of a brainstorming video. We're going to be taking a look at the peculiarities from the latest ruling, as well as the possible legal questions and conundrums which arise as a result of it, which might be of some interest to the Supreme Court. And I'm just here to throw out some ideas on the matter, and anyone is welcome to make use of them if they can. And if the CCFR does get the chance to go to the Supreme Court, then I might make a follow-up video on the ideas for how I think we can further enhance our arguments, but it doesn't make sense to really go into all of that today if we're not going to actually be going. And this video is going to be long enough as it is. And of course, before we get started, we have the obligatory disclaimer, but I am not a lawyer, I have no legal background or training, nothing in this video or on this channel should be taken as legal advice. And before we get started with what I think is wrong with the ruling, you need to understand a few basic rules about the nature of the ruling. This ruling is the result of something called a judicial review, and the courts were reviewing a number of aspects in relation to the use of the order and council powers to ban our so-called assault-style firearms back in 2020. Now, the most salient aspect of a judicial review is the standard of review. Now, most commonly, this comes down to either the reasonableness standard or the correctness standard, and which one is used depends on the issue that is being raised. Now, on the reasonableness standard, the courts are not to interfere with any decision which can be explained under a reasonable interpretation of the decision maker's powers, even if the court itself would have done something different in their place. Now, this is a concept known as deference. Under the reasonableness standard, the courts are required to defer to the decision maker's reasons and actions unless the applicants, or the appellants in this case, can show that the government acted on an unreasonable interpretation of their powers. However, the correctness standard allows the courts to assert their own reasons and their own interpretations over that of the decision maker if they want to. The current rules for reasonableness are found in the Supreme Court cases of Auer, Katz, and Vavilov. I'll explain each of these more as we go as the rules become relevant, but to simplify this idea, I have an analogy for you. So suppose you ask the question, is water wet? Well, under the correctness standard, no, water isn't wet. Water isn't wet any more than fire is burnt. So it's incorrect to say that water is wet, but it's not unreasonable to say that water is wet. However, that doesn't mean that you can just describe water in any way you want, because it is still unreasonable to say that water is dry. And now you get to think about that for the rest of the day. You're welcome. The 4 basic rules of reasonableness, as outlined in Auer, were explained by the Federal Court of Appeal in the CCFR's ruling and detailed in my previous video. So it says subordinate information must be consistent with both the specific provisions of the enabling statute and with its overriding purpose or object. Subordinate legislation benefits from a presumption of validity. The challenged subordinate legislation and the enabling statute should be interpreted using a broad and purposive approach to statutory interpretation. And a Vires review does not involve assessing the policy merits of the subordinate legislation to determine whether it's necessary, wise, or effective in practice. So, just like in Vavilov, points 2 and 3 are where the idea of deference comes from, and just like in Vavilov, the discussion of whether these gun bans are necessary, wise, or effective in practice is also unrelated to the court. All they're truly concerned with answering, or ought to be concerned with answering, is the first point. Are the governor and council's actions consistent with the statutory provisions and its overriding purpose or object? That's all they really should be answering. So, let's get into the ruling. If you want to learn more about the ruling and why we lost, as well as why I think we shouldn't have lost it, please check out my previous 2 videos in the series. This video is going to be building on many of those complaints, and we're going to start with the core issue in this case, at least so far as I'm concerned. And that's the assertion that the 2020 Order in Council was Intra Vires Section 117.15 of the Criminal Code. Now, for the benefit of those who don't know, as well as a quick reminder for those who do, we're going to go over this issue again quickly. Section 117.15 of the Criminal Code is where the government gets the OIC powers to ban firearms from, and an OIC is an Order in Council. And essentially, this law has 2 parts. Subsection 1 says that, subject to subsection 2, they have the ability to prescribe things which are to be prescribed, and in this case, that means prohibited firearms. But subsection 2 is labeled as a restriction, and it says that they cannot prescribe a firearm to be a prohibited firearm if, in the opinion of the governor and council, the firearm in question is reasonable for hunting and sporting purposes in Canada. And so, of course, our case revolves around the idea that these prohibited firearms from the 2020 Order in Council are in fact reasonable for hunting and sporting purposes in Canada, which of course they are, but the government says that they aren't because they're dangerous and therefore they're not suitable for civilian use. The government argues that their unreasonability is due to their inherent dangerousness, and that the governor and council is of the opinion that this concern for public safety is what makes them unsuitable for civilian use. These words are taken directly from the information which is attached to the Order in Council in a document known as the RIAS, the Regulatory Impact Analysis Statement. During the appeal, our side argued that public safety cannot be the only intention of the statute, because if it was, then the restriction in subsection 2 would simply have not been imposed. It would have only had one part, and that part would have allowed the governor and council to ban firearms through an Order in Council without placing any kind of limitation on it. Of course, the government argued that public safety is in fact the underlying intent of all gun control laws, and therefore that must also be true here. So we should just ignore what the statute actually says, because public safety is the only important thing when it comes to gun control measures, and nothing else can or should matter. To which our side says, okay, but if that's the case, then what purpose does subsection 2 actually serve? It's very clearly labeled as a restriction, so what restriction does it actually offer if the government can simply ban any firearm based solely and exclusively on public safety concerns? After all firearms are inherently dangerous, and therefore all firearms pose some kind of public safety risk, and therefore all firearms can be banned if that's their rationale, which would be directly contrary to the very clear intent that this subsection is to be considered as a restriction somehow. The statute is there and the wording is there, it has to mean something. And we even brought up a great many examples of Justice Minister Alan Rock clearly stating, in no uncertain terms, that the purpose of then Bill C-68, otherwise known as the Firearms Act, was to balance public safety and still permit lawful firearm ownership. He said this many, many times in many different ways, and such arguments have even been established in other Supreme Court precedent. Now, Chief Justice Montigny, from our ruling, he clearly understood all of that. He even explained most of this in reasonable enough detail over several paragraphs in his ruling. But then, he just chose to ignore it. He basically ended up ruling that the Governor and Council has broad consideration and authority on all sorts of things, and therefore it shouldn't really be constrained, which is just blatantly ignoring the constraint which was put forth by the statute, which he also very clearly agrees is there. And this is our first glimpse into some of the weirdness, but he hardly stops there. He then goes on to say, indeed, public safety was very much on the Minister of Justice and Parliament's mind when the current version of subsection 117.15.2 of the Criminal Code was adopted, as can be seen from parliamentary debates. And then he goes on to quote this exchange from committee back in 1995, where they were discussing the intended purpose of subsection 2. And this is Justice Minister Alan Rock's words. He said, now at the moment, it's possible for someone to bring a firearm into Canada, most people would agree that is not appropriate for such purposes, and then using that firearm to create shooting events, and then to rely on that event as evidence that is in fact commonly used, in order to defeat the prohibition power. This change is intended to overcome that tactic by providing that the order may be used to prohibit firearms that are not reasonable for such purposes. And I think that reflects what Canadians want to see. We don't want to have military-type assault weapons in this country that are only justified because someone has invented a shooting contest to rely upon as evidence that they then can't be prohibited. Now that might sound pretty damning at first glance, but you have to remember what the Federal Court of Appeal is trying to determine here. Chief Justice Montigny set the question in his ruling. Is subsection 2 about public safety, or is it about balancing public safety while protecting hunting and sport shooting in Canada? And this is our second glimpse into the weirdness I was talking about, because Montigny, pointing to these comments by Justice Minister Alan Rock in an attempt to prove that public safety is the purpose of the statute, is neither reasonable nor correct. Montigny needed to pay more attention to what Rock was saying. Rock isn't saying that firearms can be banned for public safety reasons. What he's saying is that hunting and sporting firearms should be protected. However, the clear concern was that the wording of the old statute would allow people a loophole to create a circumstance where the statute would then be obligated to protect more than just hunting and sporting rifles. What he's saying here is not that public safety is the purpose or the primary goal of the statute. What he's saying here is that the purpose of the statute is to protect hunting and sporting firearms, and only hunting and sporting firearms. So he's closing a loophole which might cause it to do more than exclusively just that. What he's saying is that military-type assault weapons are not reasonable for hunting or sporting purposes. Not that firearms can or should be banned purely for public safety reasons with no other factors to be considered. It's then also worth noting that the firearms we are talking about today are not assault weapons, but assault-style firearms. Not military-type firearms, not assault weapons. And one of the government's lawyers even said on the second day of the Federal Court of Appeals hearing that these are not the same thing. He said that his side has never claimed that they are assault weapons. He also said that the RIAS has never claimed that they are assault weapons. He said that the term assault style is just an arbitrary grouping term which they've decided to use to categorize firearms of a certain type, and that shouldn't be conflated with the use of the word assault weapon. He then also tried to accuse us of somehow muddying the waters on this front as though we were somehow the ones to blame for it. So both of our sides agree that the firearms being discussed today, whatever they may or may not be, are definitely not assault weapons, and therefore should not be captured by Rock's concerns here. This quote of Alan Rock clearly proves our point, and disproves the Attorney General's position that public safety is all that matters. And not only that, but there were plenty of other places in the discussion that day where Allen Rock confirmed this multiple times over. Now there's a lot to go over here, so I'm just going to be summarizing a bit of what was said, but it'll be on screen and you can pause the video to read it if you want. Jack Ramsey of the Reform Party questioned Allen Rock's motives regarding the purpose of subsection 2. And he did this by correctly pointing out, saying that, we've already banned all of these so-called assault weapons, so what is there left to prohibit? Like, after all we have left are ordinary long guns, such as rifles, shotguns, .22s, and so on. So if it's not the intent to ban such firearms, then why is the statute worded in such a way that it could allow the banning of these ordinary firearms? And Allen Rock said that this question wasn't fair, that there was no possible interpretation of the statute which could allow any government to reasonably ban such firearms. In this exchange, we can see that Allen Rock clearly demonstrates that the purpose of this section is to protect hunting and sporting firearms, not to promote some generalized idea of public safety. And then he even very specifically says this: it has to do with military-type assault weapons designed only for the purpose of combat and killing. And yet, if we look back at Chief Justice Montigny's ruling, we see that even a firearm which is designed specifically for hunting or sporting purposes is permissible to ban according to him. And that's just not an interpretation which can either be justified by the restrictions set out in the statute or by the stated intent behind the statute. And if we go back to our committee debates, the issue of this ambiguous wording was even specifically pointed out by the chairman of the committee, and he suggested that maybe the statute doesn't correctly reflect their intent, so therefore it should be reworded to specifically say that the intent of the statute is about public safety. And yet, Allen Rock refused that idea. Clearly, in the mind of Justice Minister Allen Rock, public safety is not the sole and explicit purpose of the statute. Because at the end of the day, the statute remained unamended even after that suggestion. And so we see Chief Justice Montigny engaging in reverse engineering a desired outcome and expanding the authority of the statute beyond even what the statute or the legislature intended. And Vavilov says he's not to be doing that, and neither is the government. That's not the point of reasonableness review. Because remember, according to Vavilov's reasonableness precedent, the court isn't supposed to be inserting its own interpretation of the statute. What matters is if the decision-maker's interpretation of its powers has been justified. In this instance, it's just not. We have posed serious questions about the validity of their interpretation regarding public safety and how it might be able to function as a restriction as the context of the statute mandates. But it's worth noting that it may well be that this was a blunder on behalf of the legislators. So what do you do if the intent of the statute conflicts with the wording of the statute? What do you do when the government writes down the wrong law? Well, so far as I'm aware, you follow the law. Because first and foremost, we are governed by the rule of law, not the rule of whatever that one dude said from Parliament that one time in one debate, especially not when it contradicts all of the other things that he also said in all of his other correspondence, especially when some of those things he said achieved Supreme Court precedent. And these are comments that the applicants pointed out many times during our hearings, and I've pointed to much of it and more countless times in this series. Vavilov says that the entire context is relevant and that the decision-maker's interpretation must be consistent with the text, context, and the purpose of the statute. They can't be involved in cherry-picked reasoning. It is also true from the committee evidence cited by Chief Justice Montigny that public safety is not the purpose of the statute, or at the very least, not the sole purpose of the statute. And this is actually extremely consistent with the CCFR's notion that public safety is a valid purpose of subsection 1 of the statute, but it's not the purpose of the restriction laid out in subsection 2 of the statute. Now, Chief Justice Montigny called this restriction a highly discretionary and subjective constraint, which, for what it's worth, I think that's extremely fair, so long as he remembers that the operative word there is constraint. But he doesn't do that. He circumvents the question of the constraint by using cabinet status as cabinet to duck the question of the restriction. And the Supreme Court in our cites an older case which says that this is something that Montigny, and Justice Kane for that matter, are not permitted to do. Now this goes all the way back to a case in 1943, which was discussing the use of the War Measures Act during World War II. Now we aren't going to go over the entire case here, but it is useful to know what we're talking about. So the War Measures Act, among a whole bunch of other things, gave temporary powers to the Governor and Council to pass legislation through an order in Council, provided it was necessary and advisable by reason of war. And the important part here is that this would be legislation and not regulation, which means it's equal to an enactment of Parliament even though it's coming from Cabinet and the Governor and Council instead of our democratically elected Parliament. And then the Governor and Council used these legislative powers within the War Measures Act to delegate this legislative authority to subordinate agencies outside of Cabinet, such as various boards, controllers, and other officers. And then the newly appointed Controller of Chemicals then passed some enactments on this authority, and there were questions as to how they were able to use the authority of the executive, being that they were, in fact, not part of the executive. And the presumption was that there should have been some kind of lesser authority wielded by the Controller of Chemicals because they were not the Governor and Council. However, the court found that the authority came from the statute itself, not from the office through which the authority was being used. The court found that the controller was using the same exact identical authority that the Governor and Council was using. This authority comes from the War Measures Act itself, not from the station of either office. So, how does all of this relate back to the CCFR's case? Well, in my previous video, I had originally speculated that the words from Auer, which explained that regulations derive their validity from the statute which creates the power and not from the executive body by which they are made. I speculated that that might be taken out of context and could be useful to us, but because we're taking it out of context, we can't really do anything with it. Because in Auer, they used this to prove that the standard of review does not change based on the identity of the decision maker who made it. That the reasonableness standard wouldn't somehow magically change to the correctness standard or to something else, simply because of whoever made the decision. However, tracing this quote all the way back to its origin, it's also very clear that it applies to much more than just standards of review. It proves, actually, that it does exactly what I was hoping that it would. It proves that both Justice Kane and Chief Justice Montigny made a pretty substantial mistake in their respective rulings. Both justices used the rationale that Cabinet should remain relatively unconstrained, and that Cabinet should be given wide latitude in their discretion since they are at the apex at the Canadian executive. And that is true based on previous precedent as well. But I think the way that they used it was wrong. They used it as a function of dodging the question of the statutory restriction. They incorrectly used the rationale to broaden the intent of the statute to permit it to cover a wider concept of reasonableness, which might otherwise not be substantiated. However, as the ruling shows back from the War Measures case, such rationale is actually completely inappropriate. The powers conferred by the statute do not become any broader simply because Cabinet is the one who is wielding it. And another way of thinking about this is that the reasonableness standard doesn't simply become any wider because we are referring to a decision made by Cabinet. The grant of authority is conferred by the statute, not by the office of the Governor and Council. So if the action falls within the Governor and Council's statutory powers given by 117.15, then that action should definitely not be overturned lightly, but that doesn't mean that any action taken by the Governor and Council should be given the same discretionary protection. Because before this discretionary protection applies, the courts must find that the Governor and Council acted within their statutory constraint on the reasonableness standard itself. And so what this means, very specifically for us, is that the courts shouldn't be allowed to rule that Cabinet gets to duck the question of the restriction simply because they are Cabinet. And the very recent 2024 precedent in Auer, which points all the way back to 1943, confirms this. And simply speaking, this means that under the reasonableness standard, regulations and other subordinate legislation are not to be considered more reasonable simply because they come from Cabinet. This is an error that both Justice Kane and Chief Justice Montigny make, and most importantly, this is exactly the kind of question that would tickle the Supreme Court's fancy. And Auer also confirms this in its own words alongside Vavilov, that the authority of the statute doesn't become any broader simply because of the executive body which wields that power. In paragraph 43 of Auer, it clearly states from Vavilov that Vavilov noted the, quote, sheer variety of administrative decisions and decision makers, and yet confirmed that reasonableness is a single standard that takes account of this diversity. Yet despite that, both our federal court ruling as well as the ruling from the Federal Court of Appeal now have given inappropriate considerations in relation to the justification of the use of the OIC powers. And more than that, Auer, when quoting from Katz, says that the court is not to be assessing the policy merits of a decision. The court should not be considering whether this gun ban is wise, necessary, or effective in practice, nor should it be considering any kind of underlying political, economic, social, or partisan considerations. And that's a mistake, frankly, which happens over and over from Chief Justice Montigny. Things like public interest is an underlying social consideration. Despite what the Federal Court of Appeal ruled, it should have no bearing on the interpretation of the statute. Like, for example, Montigny says this in his ruling. He says, for that reason, factually suffused decisions made by Cabinet based on wide considerations of public policy, will be relatively unconstrained and not normally second-guessed by the courts. But the statute doesn't actually encourage Cabinet to engage in wide considerations of public policy or of public interest. It exists to restrict, not broaden, the considerations by which Cabinet can prohibit firearms. Like, if the word restriction wasn't there, then the government's interpretation of their statute would still be incorrect in my opinion, but it might not be unreasonable. However, the word is there. It is clear that the statute must be viewed in the context of a restriction. Like, it's not reasonable to expect that the statute would function in some way which doesn't restrict the government's power in some fashion, however slight. Like, it's not reasonable to suppose that Cabinet can operate on an interpretation of public safety alone, because there's just no inherent restriction in that. Not even by the tiniest amount. Now, Cabinet might draw their own artificial and arbitrary lines as to how far they want to take this power. Like, for example, they may just actually decide that they will never ban all bolt-action rifles with this power. But if the idea here is that they will somehow restrict themselves and operate on the honor system, that is not a restriction. Because suppose they did actually want to ban all bolt-action rifles. Would the courts be allowed to intervene? Like, suppose Cabinet a year from now passes an order in council to ban any firearm with a magazine, including all bolt action, all lever action, pump actions, tubes, like the whole 9 yards, and they would leave us only with single-shot firearms. Could the courts stop them from doing that according to this ruling? No. No, they actually could not. The discretion of Cabinet is not to be interfered with according to the courts. And such a thing would be very consistent with the idea of public safety if the courts are allowed to incorrectly rule that public safety is the sole purpose of the statute. The discretion of Cabinet is not to be interfered with according to the courts, and frankly I agree with that. And so such a thing would be consistent with the idea of public safety if the courts are allowed to incorrectly rule that public safety has to be the sole purpose of the statute. So if you place no hard and fast conceptual limitations on this power as the statute requires, then Cabinet's discretion under the sole authority of public safety lets them take this as far as they want. The question the courts are to be answering is not whether or not it's good policy this time around. The courts are supposed to be considering only the scope of the powers afforded by the statute. Whatever Cabinet may or may not be using the powers for this time around is not a relevant consideration. And this is a mistake that both Justice Kane as well as Chief Justice Montigny made in their rulings. After all, like in their own minds, it may well be that the banning of assault-style firearms may be a reasonable thing for the government to do. But that's not the question they need to be answering here. For example, in both rulings, the idea of these gun bans being more reasonable due to these firearms being unnecessary for hunting and sport was an idea which actually came up a lot. The court said that the availability of alternatives for hunting and sport was a valid consideration that the governor and council could make. Now, I disagree with this pretty heavily for a number of reasons, not the least of which is that it actually speaks to the wisdom of the policy, which the courts are not supposed to be allowed to consider. But if we do think it's a valid consideration, that means very explicitly that the governor and council is required to be considering more than just public safety. Which, again, by the way, aligns more with our position than it does the government's. Like, if necessity is part of the calculation, then consider this. Suppose there were only one model of firearm in the world available for hunting and sporting purposes. But suppose that firearm was a belt-fed 50 BMG machine gun with a 100-round belt, and it fired exclusively Raufoss rounds. Being that such a firearm would be absolutely necessary for hunting and sport, would the governor and council be unable to ban it in the name of public safety? Now, I would argue that such a firearm is unreasonable independent of whether or not it's necessary, because I think necessity is unrelated to the statute entirely. But under the government and the court's insistence that necessity is relevant, that firearm should become reasonable out of necessity alone. And if that firearm does become reasonable, then are they truly operating solely on the idea of public safety? Does my explosive 50 caliber machine gun pose any less of a threat to public safety because there are no other alternatives for me to be using? Of course not. It's a completely ridiculous idea. But this does go to show that both the courts and the government agree that even on their incorrect and unreasonable interpretation of their powers, the governor and council is expected to somehow manage a balance between public safety and hunting and sporting use. Now, obviously, that was a pretty extreme example, but pointing out that their idea of necessity being somehow relevant is actually functionally useful for us. Because where would we draw these lines? How would we determine exactly how much discretion the governor and council should give to either side of this balancing act? And the answer is, we don't. It would be inappropriate for anyone, even the courts, to interfere with this act of discretion from the governor and council. It would be entirely up to cabinet to determine what would be reasonable in the circumstance and what balance to strike between public safety and hunting and sporting. And this includes giving absolutely zero consideration to hunting and sporting firearms and the wholesale banning of firearms in the name of public safety. And this is what it means to be at the apex of the executive and to not have your discretion interfered with. However, the courts are inappropriately applying that discretion from cabinet to expand the scope of the reasonableness standard itself. Because now that the court has ruled that public safety is the only concern to the framework of the decision, and that there should be no restrictions on this public safety discretion from cabinet, you can do some pretty wild things with the OIC powers. For example, for the purposes of our judicial reviews, we've been focused on the powers in 117.15 of the Criminal Code as an instrument for prohibiting firearms as a result of an order in council. But it can restrict or prohibit all sorts of other things as well. And this includes things like ammunition, other devices, as well as other weapons which are not firearms. So, what can be prescribed as a prohibited weapon? Well, Section 84 of the Criminal Code says that it can be any weapon other than a firearm. So, what is a weapon? Well, Section 2 of the Criminal Code says that a weapon is anything which is used, designed to be used, or intended for use in causing death or injury to any person. I'm about to go down a bit of a rabbit hole here, but please stick with me. Is a baseball bat a weapon? This definition from the Criminal Code would say yes. It can undoubtedly be used to cause injury or death to a person. And if a baseball bat is a weapon, it can also be prescribed as a prohibited weapon by Section 117.15 of the Criminal Code. So here's the question. Is a baseball bat unreasonable for hunting or sporting purposes in Canada? And if you want to play along here, maybe pause the video for a bit and think about this, because the answer is really not as straightforward as you think it is. So, a baseball bat is probably unreasonable for hunting, although some people do use them for fishing to make a fish stop flopping around after you catch it. It's a little brutal, but I don't know if that really qualifies as, hunting. It's a bit of a weak argument. Like, you're not going to be chasing a deer through a forest with a baseball bat. Like, come on. It's probably not reasonable for hunting. Moving on. Is a baseball bat reasonable for sporting purposes in Canada? I mean, yeah? Like, baseball bats are perfectly reasonable for the sport of baseball. Now, you might be able to argue that there are other sports to participate in, and sure, that's actually true, but that's an irrelevant consideration in relation to whether baseball bats are reasonable for the use in baseball. Like, a baseball bat is not more or less reasonable for baseball on the grounds that you can simply play other sports. The statutory test is whether the weapon is reasonable for the sport, not whether the sport itself is reasonable. However, based on the rulings from both Justice Kane and Chief Justice Montigny, the government has the ability to ban baseball bats because they're unreasonable for use in baseball, solely because they pose a public safety risk since they can be used as a weapon to hurt people. That may sound a little bit silly, but that's not an exaggeration. Now, you could certainly argue that the government would never actually do that, and I agree, they probably will never actually do that. But the question the courts are to be concerned with is not whether or not cabinet will do that with the statute, not what they are going to do with the statute, it's simply what they can do with the statute. An exclusive public safety only focus gives cabinet the authority to ban baseball bats. Now, I know what some of you are already thinking. Baseball, huh? But the rest of you would probably say that I'm taking this argument to some ridiculous extreme because neither Justice Minister Alan Rock nor any other MP ever suggested anything even remotely like this when expressing their intent about the provisions in the Section 117.15 statute. To which I would say, you are absolutely correct. This baseball analogy goes far beyond any sane or reasonable interpretation of what Parliament was trying to achieve with the changes they made to Section 117.15 of the Criminal Code way back in 1995. And yet, this baseball analogy is completely consistent with the notion of a public safety only rationale, which means public safety cannot be the sole purpose of the statute as the courts and the government claim that it is, because if it is, it lets them do some pretty ridiculous things with the OIC powers which were clearly never intended by its authors. Now here's an even funner question, which gets us to the bottom of this issue. Are all baseball bats reasonable for use in baseball? And no, actually they're not. In the rules of baseball, the baseball bat is one of the most strictly regulated pieces of equipment on the field. Now mostly this pertains to its dimensions, which you might call its characteristics, and also the materials that it's made of, which are more indicative of its capabilities. In particular, corked bats are illegal because they make the bat lighter, and this makes the bat easier to swing, resulting in an unfair competitive advantage. In other words, it's just cheating. Therefore, corked bats are not reasonable for the sport. But there is another kind of bat which is not allowed in the MLB. Metallic bats. Bats made out of metal are not allowed in the MLB due to concerns over player safety within the sport itself. Metallic bats can produce return velocities above reasonable human response time to infielders on the opposing team, which can result in significant injuries such as TBIs. There are also concerns that metal bats are too easy to use, and therefore they don't appropriately challenge the skill of the batter, making the sport much less skill-based. Which is actually kind of curious, because the Supreme Court said something very similar about firearms in Hasselwander, specifically that automatic firearms, such as assault rifles, are not designed to test the skill or accuracy of the marksman, and that this is part of what differentiates them from semi-automatic firearms, which therefore must be designed to test the skill and the accuracy of a marksman. And likewise, firearms which are reasonable within the confines of the rules of a well-established international sport like IPSC would have to be reasonable for sporting purposes. Clearly, a well-established sport like IPSC would have to fall outside of the concerns of the loopholes that Alan Rock described, wherein people could invent a sport to gain protection under the old commonly used threshold of subsection 2. So unless the Governor and Council could demonstrate some practical or safety issue pertaining to a particular firearm's use within the confines of the sport itself, which by the way is far from impossible, then the Governor and Council should be required to leave that firearm alone. Otherwise, they would have some pretty significant and wide-sweeping powers to dive into the private recreational lives of Canadians, which goes well beyond what 117.15 clearly intends. Now, all of this isn't to say that our hunting and sporting firearms are somehow untouchable, or that even baseball bats, for that matter, are untouchable, but rather it requires the government to enact new legislation before these things can be banned. Now, if the CCFR is able to get to the Supreme Court, I'll be sure to make a separate video on some of the other things that we could say in regards to the Intra Vires argument, because there are actually a number of other things we could say to shore up these arguments and evolve their own arguments. For example, there was a lot of talk about the formation of the necessary opinion, which is required by the statute, and the CCFR has been chasing this for 2 reviews now. But in reality, the use of the OIC power actually requires the formation of 2 opinions. Not explaining it this way allows the courts to substitute any opinion, such as the public safety opinion, as the necessary opinion, which only confuses the matter. And this is what happened with Chief Justice Montigny in the Federal Court of Appeals ruling. And there's way more topics and evolutions which can be raised than just that, but this video is already plenty long and there's still more to cover. And that'll be its own video if and when it becomes necessary to make, so for now, we're going to be moving on. And the next area where I think Chief Justice Montigny did something demonstrably weird was in regards to his ruling on vagueness, and therefore also the unlawful subdelegation of authority. Now, vagueness is a constitutional issue under Section 7 of the Charter, and so now the correctness standard applies, which is a significantly less generous standard for the government. And most importantly, this standard no longer requires the courts to defer to the government's interpretation of their powers, and allows the court to assert their own interpretations in a much stricter fashion. Vagueness is something of a flexible standard in and of itself, but correctness is not. I think this point is actually far easier to prove to a court, but the remedy would likely be much less, but we'll talk about that at the end. So I think Chief Justice Montigny shatters the entire case the government made in regards to vagueness when he cited the precedent of Actton Transport versus Steves. Yet somehow he of course still ruled in their favor anyways. Now, part of the reason for this is probably that he cited that precedent in the subdelegation of authority section and not the vagueness section of his ruling, but given how much overlap there is between these ideas, Actton actually has a little bit to say in regards to vagueness as well. Now, for you to understand all this, you need a quick brief on what vagueness is, as well as what the case of Actton Transport is. Vagueness is a constitutional issue under Section 7 of the Charter, as it is considered to be one of the principles of fundamental justice. Now, this is going to be a quick explanation as I've discussed it in more detail so many times throughout this series so far, but everyone has heard of the idea that ignorance of the law is not innocence of the law, and fair enough. But if it's not even possible to know what the law is, then that becomes an issue of vagueness. Precedent says that if the law is so lacking in precision that it does not provide sufficient guidance for legal debate as to the scope of prohibited conduct or an area of risk, then it is vague. The doctrine of vagueness is directed at ensuring fair notice to citizens and limiting enforcement discretion of officials. During the hearing, most of the applicants argued in one form or another that the word variant is too vague to be used in the regulation since there's no definition for the word variant. Like, we can't know what a variant is even if we want to avoid having one, meaning we can't comply with the law even if we're actually trying to. Now, both courts now have ruled that this is okay because we can just rely on the firearms reference table provided by the Specialized Firearms Support Services, but if that were true, then that must also be indicative of an unlawful subdelegation of authority to the RCMP, because the Governor and Council can't hand down its criminal lawmaking power down to the RCMP, who would then also be enforcing those laws that they're making. Now, the courts get around this by saying that it's okay for the RCMP to do this because the firearms reference table is not legally binding, and the courts are the ones who ultimately make the decision. But if it's not legally binding, then how does looking at the firearms reference table protect us from the issue of vagueness? If it holds absolutely no legal authority, then it also offers zero legal guidance or protection on the issue of vagueness. And this leads to an obvious issue of cyclical reasoning, which no court seems willing to fix or even to admit that it exists. Now, a quick explanation of the precedent in Acton Transport versus Steves and how that relates to our issue. Essentially, this case was about determining the appropriate overtime pay for a particular employee. The employee would be paid differently based on whether or not they were a city motor vehicle operator or a highway motor vehicle operator. And whether a driver is one or the other may depend on the prevailing industry practice in the geographical area where they are employed. Now, the big difference here was that city drivers would get overtime after 45 hours of work in a week, but highway drivers would not get overtime until after 60 hours of work, which, given enough weeks, that would obviously add up to a pretty significant pay difference. Acton's argument was that by leaving it to an official to determine the prevailing industry practice, the Governor and Council transformed a legislative power into an administrative power, which amounts to an unlawful subdelegation of authority, much like in the CCFR's case where they alleged that the classification of firearms on the firearms reference table is also an unlawful subdelegation of authority to the Specialized Firearms Support Services of the RCMP. Now, back to the case of Acton. The court found that there was no subdelegation of authority. Distinguishing between a city or highway driver on the basis of the prevailing industry practice satisfies the legislative mandate since the prevailing industry practice is a question of fact and not a matter of an administrative discretion. Determining the prevailing practice is an action of fact-finding, not legislating. And more importantly, where a delegating decision maker is authorized to decide certain questions by the regulation which promulgates it must actually decide the question. So what would this mean in relation to firearms? Well, take that rifle on the rack behind me. That is a Tikka T3X. It is a non-restricted firearm. But how would we go about confirming that it is, in fact, a non-restricted firearm? Well, we'd consult the definition of a non-restricted firearm in Section 84 of the Criminal Code. And there it says that a non-restricted firearm is a firearm which is neither restricted nor prohibited. And these classifications generally come down to little more than the physical dimensions of the firearms. And so for simplicity's sake, we're just going to prove that it's not a restricted firearm. It's a bolt-action rifle, which means we look at Section C of the definition, and it says that we're in the clear if the firearm is greater in length than 660 millimeters. So, we bust out a tape measure, we grab the rifle, and we find out that it is well above that restricted length. So therefore, it is not a restricted firearm. It is an unrestricted firearm or a non-restricted firearm. Great. Did the government delegate me any authority to make that determination? No. What a non-restricted firearm is or isn't was already determined by the Criminal Code. We made no decisions. All we did is that we merely engaged in fact-finding based on a pre-existing legislative framework. The Criminal Code itself determined what questions we had to ask in order to find out if that was a non-restricted firearm. We also had a very clear and very unambiguous path to follow on that fact-finding mission, so the definition isn't vague either. So in the CCFR's court case, that's essentially what the judge is saying the Specialized Firearms Support Service is doing with their firearms reference table. It's not a subdelegation of authority because they're just engaged in fact-finding, and the questions have already been determined by the Criminal Code and other regulations. Plus, it's also not a subdelegation of authority because they are not a legally binding entity, so whatever determinations are being made by the Specialized Firearms Support Service are essentially of no consequence. At least, that's what the court thinks. So ultimately, all that matters are the interpretations put forth by the court. And so far, all of this makes sense. The issue of vagueness arises when we encounter the topic of variance. Like, suppose I want to engage in a fact-finding mission to determine if my Tikka back there is a variant of some other firearm in exactly the same way as we determined that it was a non-restricted rifle. How do we actually do that? Could we look at the criminal code? Nope. No definition of the word variant exists or is found there. Can we look to the regulations where the word is regularly used? Nope. It's not defined there either. And this is where the idea of vagueness lands us. How do we actually figure out whether or not my Tikka is a prohibited variant? And the answer isn't simply as bad as we don't know if my Tikka is a prohibited variant, but rather, it's actually not possible for us to know if our Tikka is a prohibited variant. And it's not possible to know because there has been no guidance offered anywhere at any point by the government or the governor and council who made these regulations. Not in the code, not in the regulations, not in the RIAS, not anywhere. This means that before we can engage on the fact-finding mission as to determine whether or not we have a variant, we also have to embark on an asking questions about what it means to be a variant. And Actton says that we are not supposed to be doing that. Only the governor and council has the authority to be making those questions, and those questions are simply to be dictated to us by way of regulation. The governor and council is not allowed to simply confer upon us the power to make these questions when these questions are his or her responsibility to make. And this all becomes blatantly obvious in paragraph 27 of Actton, where it says, "The intention of the legislation is clear. Prevailing industry practice is to be taken into account when categorizing a motor vehicle operator as either a city or highway operator." Have you ever heard of Mad Libs? Well, let's replace those 3 underlined criteria with their firearm-related counterparts to demonstrate, beyond any doubt, that the undefined use of the word variant is vague. Well, go ahead, fill in the blank. What is to be taken into account when categorizing a firearm as a variant? The government has provided no guidance, no framework, no definition, no anything on this. And this conflicts with what Actton says about vagueness. Like, if there was some guidance or some definition about what a variant was from the government, then you could argue that the Specialized Firearms Support Service or the courts are merely engaging in a fact-finding mission, as Actton says. But so long as that area remains blank, the courts and the Specialized Firearms Support Service are the ones who are deciding the question. And according to Actton, that's not permitted. Now, the government tries to get around this by saying that the definition for the word variant is so obvious that it doesn't need to be defined because it's so obvious. But even something as non-specific as the prevailing industry practice, which is used in Actton, doesn't work for the word variant because even the government expert, Mr. Smith, agrees that there is no standard industry definition. He confirmed that there is no legislative definition either. And not only that, but he confirms that even within the RCMP, they use the ordinary meaning of the word variant. But if there was such a thing as the ordinary definition, shouldn't the industry know about it and know how to use it in a standard way? And should the legislature be able to very easily write it down into a statute to give us that guidance? Like, it doesn't make any sense. Like, the Specialized Firearms Support Service has been doing this so long, and they've been encountering this question so often, that they themselves have invented their own ordinary meaning, which is a cacophony of things that changes from one firearm to the next, varying in importance from one firearm to the next, but that is still their own invented definition, that is still their own question, and they're not supposed to be doing that. That's the responsibility, in this case, of the governor and council. So let's get back to the Tikka. There's another term which is often used colloquially to describe non-restricted firearms. We usually call them long guns. Like, everyone knows what a long gun is, right? Well, suppose that was the entire definition for a non-restricted firearm. Suppose the law actually said that long guns are non-restricted, that short guns are restricted, and that tiny guns and automatic firearms are prohibited. Which, by the way, is actually a pretty accurate, albeit very basic description of what the law already says if you don't include the OIC powers. So, what makes a long gun long? Is it obvious? Could we use the dictionary definition? Surely no one would contend that we don't know what the words long or short mean, right? Like, they're used every day. It should be obvious. Do we use an industry definition? A short rifle is surely longer than a long handgun. Does that mean a short rifle is still a long gun? How long is long? Should it change based on the firearm's design? Should it change based on the firearm's caliber? Should it change based on whether or not the firearm can fold or telescope? Does it include barrel length or is it just all length? Does it include pin and weld lengths or only true lengths? Like, there are nearly limitless number of questions you could ask to determine what a long gun could be. And depending on who is asking the question, the specific combination of criteria would undoubtedly be different from one person to the next, resulting in arbitrariness. And the government avoided all of that by simply setting very specific and very unambiguous size parameters in these respective size categories, thereby solving any possible issue of vagueness. So if saying long guns wouldn't fly, then why is it okay to simply say variant without any guidance? Even the government expert agreed that there was absolutely no guidance. And not having this guidance creates contradictions and inconsistencies. And one such example was actually pointed out to me by a viewer by the username of the One-Armed Bandit regarding one of the banned firearms from the 2020 OIC list, the Stag 10. Back in 2019, the Stag 10 was very clearly and very specifically listed on the firearms reference table as a non-restricted firearm, and as definitely not being a variant of any other known firearm. But you fast forward 1 year, and the Order in Council listed it as a named variant of the AR-15 under Section 87 of the regulations. This means that the Specialized Firearms Support Service and the Governor and Council are operating on different ideas of what a variant is. And then you come to something more recently, the Crusader Arms Crypto. It was built from the ground up with the idea of complying with C21's evergreen definition of what constitutes an assault-style firearm, meaning that by legislative standards, the Crypto was not an assault-style firearm and therefore couldn't be a variant of an assault-style firearm. And this was confirmed by the fact that it survived both the second and third OICs from the government without being prohibited. Despite that, it received prohibited status by the Specialized Firearms Support Service shortly thereafter, which again indicates that the so-called experts and cabinet are working on different ideas of what a variant is or what an assault-style firearm is. But it also shows us something else. It also shows us that the RCMP has the authority to ban firearms that even the government considers to be okay. Like, if the firearm was not okay in some fashion, it would have definitely been banned by Cabinet in one of their order and councils, and Parliament wouldn't have specifically legislated parameters to allow it. It also demonstrates that even the firearm industry can't know what a variant is. The word variant is even so unclear that professional firearms manufacturers failed to make a compliant firearm even though they were very clearly attempting to do so. So forget about any talk as to whether or not a civilian should know what it means, or that there is some kind of industry consensus as to the use of the word variant, because even between the government and the RCMP, there is disagreement over what this word means. But it doesn't even just stop there, because even within Cabinet's own internal rationale, there is no consistency as to what an assault-style firearm may or may not be, or what a variant may or may not be. And this was pointed out to me by a fellow YouTuber whom many of you know. His name is Daniel Fritter, and he runs the channel by the name of Caliber Magazine, which is also an actual magazine, by the way. If you don't know who he is, you should definitely go check out his channel and subscribe to him because he really knows his stuff. Anyway, he did a video a couple of months ago where he demonstrated this point rather well for us. The government's Order in Council tends to focus on what they call families of firearms. They find a head of a family, which is allegedly somehow of a military design or origin, and then they find relatives to that head of family, which are the variants of that assault-style firearm. Like, basically what they do is they create a little family tree of parents and children to ban an entire lineage of firearm design. Or at least that's what they claim to be doing. However, being that they never actually define any of these terms, they can arbitrarily adjust this rationale anytime they want, and Caliber Mag demonstrates this in his video.
They are the same gun. FN owns Browning and Winchester. When in the early 2000s, late 1990s, when the Browning BAR was getting a little bit long in the tooth, they created 2 additional models of the rifle, basically looking to brand engineer and leverage the brands Winchester and FN to create additional revenue off of the Portugal Browning BAR production line by creating an FNAR, which was marketed as a law enforcement rifle and European competition rifle for markets that didn't want to be seen as militarized by buying AR-10s for their police officers, because this is a 308, and competition guns in markets where AR-15s were not legal. And the Winchester SXAR was largely supposed to be sort of the cheaper version of the Browning BAR, which is broadly recognized as a luxury hunting gun of some sort because it's a well-finished and relatively expensive gun. So it was a synthetic stocked, hydro-dipped camo version of the Browning BAR. And when I say version, I mean version. They all came out of the same factory. I'll throw a picture up here. You can see they are the same rifle. The only difference is the finish and the branding on the side of the gun. But two of them are now prohibited and one isn't. I would allege that the reason that the Browning BAR remains non-restricted is because although the Browning BAR match, specifically the FNAR and the Winchester SXAR, are the exact same gun, it is very difficult for the government to separate a single model of Browning BAR in the match model and prohibit that gun without it impacting the larger parent entry on the firearms reference table of the Browning BAR, because effectively, this is where that variant term kind of comes and bites the government in the you-know-what and turns around on them, is that the Browning BAR match is, by most people's definition, likely considered a variant of the Browning BAR. However, the FNAR and the Winchester SXAR, by virtue of being under two different brands with distinct model designations, does not need to impact the Browning BAR record. And since the Browning BAR is very much recognized by Canadians as a hunting rifle, it has been carved out and exempted from the prohibitions impacting its two exact siblings. And I think that with those three pieces of evidence, you can kind of get a very comprehensive notion that what the Liberals have been trying to do for the past 5 years is prohibit everything that cannot be put forward to the public on a perception basis as hunting rifles.
He speaks of the Browning bar, which is the parent design of other firearms in the same lineage, which were then themselves declared as parents rather than as children of the bar or variants of the original bar as they normally should have been. And this is because the bar is very clearly of a hunting design and is something of a renowned hunting design. However, these other firearms have the exact same, completely identical design, but they were marketed for more sporting purposes. And so new lineages were artificially attributed to them out of character by Cabinet in order to ban these rifles while keeping the original hunting firearm unscathed, even though in reality they're part of the same lineage. Which means we have proven once again, for the umpteenth time in this series, whatever a variant is or isn't, or whatever an assault-style firearm is or isn't, it genuinely has nothing to do with the design of the firearm, and it never has. And this also demonstrates why the government wants to keep the word as vague as possible. It allows them infinite flexibility to ban anything they want, anytime they want, without any kind of accountability or scrutiny on the decision. But vagueness exists to protect against this kind of arbitrariness in the law. That is the entire sole explicit reason why vagueness is considered to be fundamentally unjust. Now, both of our courts ruled that the word variant is still not impermissibly vague, because there was a single case which happened once like 15 to 20 years ago, wherein they actually had to discuss the word variant, and therefore this must mean that there is sufficient understanding as to what a variant is as to guide legal debate. But I would seriously question that assertion by the courts, because the case in question, the Crown versus Henderson, does not appear to actually indicate any such thing. I spoke about Henderson in part 1 of the series if you want to learn more about it, but of course, here's a quick summary. Henderson basically came down to determining whether or not the firearm, the AP-80, was an unnamed variant of the AK-47, which itself was a prohibited firearm. The Ontario Court of Justice ruled that it wasn't, stating that despite its similar physical appearance to an AK-47, it was still merely a semi-automatic .22, which was no different than really any other kind of legally available semi-automatic .22. The Ontario Court of Justice held that for the AP-80 to be a variant, it must be similar in both its appearance and its capabilities, in particular that capability being automatic fire. This reasoning was based on his interpretation of the dictionary definition of the word variant, as well as concerns for public safety. However, then the government appealed that decision, and the Ontario Court of Appeal struck down the previous ruling, stating that the AP-80 was identical to the AK-22, which itself was a named variant of the AK-47. And therefore, the AP-80 is clearly a prohibited variant. This made it an unnamed variant of a named variant of the AK-47. And for what it's worth, I don't like the ruling, but I think the appeals court got it right here based on the way the regulations are supposed to work. So here's the problem with the Henderson precedent, though. As has been stated by Justice Kane as well as Chief Justice Montigny, a variant is a variant even if it's not listed in the regulation. And these variants are referred to as unnamed variants. What this means is that whether or not a firearm is a variant is not a subjective answer, but rather, it's a substantive answer of objective truth. This means basically that the AP-80 was always a prohibited variant, whether or not it was named. But this also means that the AK-22 is a prohibited variant, whether or not it is named. So riddle me this. Suppose the AK-47 had no named variants. And this is actually plenty common in the regulations, and there's all sorts of examples of firearms on the list, which are a family of one. So if it's objectively true that the AP-80 and the AK-22 have been, and always shall be, variants of the AK-47, then how would we go about proving it if we had no other named variants to cross-reference them with? Because when the Ontario Court of Justice attempted to determine whether the AP-80 was a variant of the AK-47, he did so using the plain meaning of the word, and then applied that plain meaning through the context of a public safety lens in a very sensible fashion. And what he found was that the AP-80 was not a variant. Now this is a pretty big issue because this is not just a matter of a difference of opinion. This means that he was wrong so far as the law and the regulations were concerned. But without the evidence of the other named variants, such as the AK-22, how would we still confirm that the Ontario Court of Justice actually got it wrong? Like, what question would we ask? What standard could we check? What information should we confer? Or what statute should we reference to ensure that we can overturn the lower court's legally faulty ruling? Well, the answer is that there isn't anything that we can check. And this is because the word variant is vague. So when you really analyze the precedent in Henderson and break it down all the way, I think it actually really identifies the vagueness problem better than any other piece of evidence that either party brought forward. If the CCFR gets to the Supreme Court, I really hope they choose to bring this up, because I think it really could be the tipping point to getting us into a favorable ruling territory. Like, the only real evidence the Attorney General had for its justification for vagueness was this case. And if we can flip it on them, the government's case really falls apart on this front. The benefit of this was already explained from Justice Kane's ruling, where the Minister of Justice observed that any attempt at a proposed definition would result in complications, which predominantly would probably mean that tons of models of firearms would no longer belong on the ban list, and therefore they would all become legal again. It wouldn't strike down the whole list or anything, but it would return a good chunk of them to their previous classification status. At least that's one possible remedy anyway. Now, unfortunately, vagueness can still be justified under Section 1 of the Charter. So even though Actton and Henderson do a pretty good job of proving vagueness for us, the court can still say that the vagueness is acceptable as a matter of public safety under Section 1. However, infringing on our Section 1 Charter rights is supposed to require the government to demonstrably prove that the infringement of our rights is justified in the name of some greater societal good. At least, that's the idea anyway. In reality, the judges from both rulings have already preemptively decided, without any prompting or evidence from the government, that this vagueness would be justified under Section 1. Because after all, we're just law-abiding gun owners, and the courts have long decided that our mere existence is such a menace to society that we should not be afforded any of the charter rights that the rest of Canadians are owed. Like, I don't know about you, but I certainly don't remember signing away all of my fundamental rights and freedoms when I applied for my firearms license. So we would also need to head this nonsense off at the pass and disprove it of our own accord if we can discuss this vagueness at the Supreme Court. But that is about all I have to suggest regarding ideas for the Supreme Court. But there are other benefits involved in helping our case if we can actually get there. And one of the advantages of going to the Supreme Court is that the two new order and councils would probably become relevant to the discussion. And this would help to prove that the government isn't only going after some firearms, or only after modern firearms, or popular firearms, or firearms of a certain style, or anything like that as they originally claimed they were. And it would also be useful to point to Bendian's press conference about the announcement, where she clearly asserts that the SKS is an assault-style firearm, but also that the firearm is still reasonable for use in Canada for hunting and sporting purposes. And we should be able to speak to the new regulations without any issue, but we would likely have to apply for leave to submit new evidence to get something like Bendian's press conference submitted to the hearing. However, given how incredibly relevant it is to the case, as it is the government's complimentary statements made on behalf of the Third Order and Council, I can't imagine any such thing would be denied. And there are other benefits. Specifically, the Supreme Court has the ability to overturn previous precedents. Now, I don't know if this can happen organically or if there's some specific process or procedure by which you have to request the court to take a look at it, but that could be very useful in proving our Section 15 Charter challenge against discrimination or the infringements to the property rights in the Bill of Rights if we are able to bring up these points. But I also don't really have any idea how the application process works or what burden of proof is required to get us to the Supreme Court. Like, I've read a pretty dizzying amount of Supreme Court rulings over the last couple of years here, but I don't really have any experience or any idea of what goes into the other side of the process of actually getting there to be heard in the first place. So despite all that I've said here, it might be that none of this is actually relevant. But like I say, this was just a brainstorming video, and maybe it can inspire the right minds in the right ways to ask the right questions to get the right outcomes that we need. All that being said, I'd like to thank you all for watching, and we'll see you in the next video.